Hi, welcome to our webinar on employment disputes, legal insights for employers. My name is Paula Kumar and I'm a practice leader in LegalVision's disputes team. Before we begin, there's just a couple of quick housekeeping items for you to understand. So you'll receive the recording and slides in your email. You can submit your questions in the Q&A box and we'll answer them at the end of this webinar. And also there's a feedback survey after the webinar, which we'd be grateful if you could complete. For the next 48 hours, you are eligible for a 3 consultation with LegalVision to discuss how we can help your business. So if you can provide your contact details in the survey at the end of the webinar, we'll be sure to get in contact with you and discuss how we can help your business. Before we get started on today's webinar, we just thought we'd do a little poll for you. And really wanted to understand what aspect of employment disputes do you find the most challenging? So the options that we have are identifying the most common risks and dispute types, resolving issues early through internal procedures or ADR, preparing for and defending tribunal claims, weighing up the financial impact of settling versus litigating, or you're not sure and you're just here to sit and learn. So I'll just give you a couple of moments to identify which is the most appropriate option for you. Okay, so the most popular option, we've got 2. One is resolving issues early through internal procedures or ADR, and the other one is not here, just I'm not sure, just here to learn, which is great. So yeah, I mean, in terms of early procedures, we'll be going through how early resolution can really save significant time and costs when you compare that to formal litigation, and the importance of having really kind of clear and well communicated grievance processes. So we'll go into that in a little bit. So the next thing that we want to talk about is the agenda. So the agenda for today is, firstly, we'll be discussing the most common risks and dispute types, and then we'll be talking about resolving issues early through internal procedures or ADR, preparing for and defending tribunal claims, and weighing up the financial impacts of settling in versus litigating, and then we'll be having the Q&A session. So when we look at the most common types of employment disputes in the UK, the biggest one remains unfair dismissal. This is one of the most frequent claims that we see in UK employment tribunals. The main act legislation that we've got in this area is the Employment Rights Act 1996, which sets out the legal framework. And unfair dismissal claims arise where an employee believes that they have been dismissed where there's been no fair reason or a proper procedure. So the Act outlines 5 potentially fair reasons for dismissal. And those reasons are conduct, capability, redundancy, illegality, or some other substantial reason. And it's not just about having a fair reason. So the process is really important too. And employers have to be really careful that they follow a fair procedure and act reasonably. The other important thing to note for unfair dismissal claims is that employees have to have 2 years continuous service currently to bring a claim, although there are some exceptions to that. We're going to look at a recent case that is important in this area, which is Function versus the Royal Mail Group. And this was a postal worker who had a significant health-related absence during his employment, and he was offered some reduced working hours, which he refused. He then issued a claim for disability discrimination and unfair dismissal. And the Employment Appeal Tribunal found that the employer should have considered redeployment in the context of the unfair dismissal claim only. So what does this mean? Well, this case really reminds employers that they must still consider the full range of sanctions that is available before you resort to thinking about potential dismissal. And this is even more true in cases where absence is linked to health issues, as it was in this particular case. Now we'll look at the next most common claim that arises in tribunal matters, and this is discrimination. You've got the Equality Act 2010, which protects employees from discrimination based on 9 characteristics, which are age, disability, gender, reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. So one example is where a female employee is passed over for promotion in favour of a less qualified male colleague. That could potentially amount to sex discrimination. A key case in this matter was really kind of crucial for understanding the balance between religious beliefs and discrimination. There was a Christian doctor who refused to use transgender patients' preferred pronouns due to his religious beliefs. He then claimed discrimination when his contract was terminated. And the Employment Appeal Tribunal, in this case, distinguished between holding a belief, which is protected, and manifesting that belief in a way that discriminates against others, which is not protected. So this case really helps employers navigate the complex intersection of religious belief and potential discrimination in the workplace. And it really highlights the need for careful consideration when balancing different protected characteristics and the importance of having an inclusive workplace policy and environment as well. Now we'll look at wage and hour disputes. So these are kind of more typical standard disputes, such as where there's a national minimum wage violation or unpaid overtime or holiday pay discrepancies, or it could also be an unlawful deduction from wages. So one of the key cases in this area was regarding holiday pay calculations. And the court in this case ruled that voluntary overtime should be included in overtime if it's sufficiently regular and settled. So if it was a one-off, that wouldn't be included for the purpose of holiday pay. But if you've got something that's very regularly done, then if they're regularly doing overtime, then that should actually be included in holiday pay. And that's quite an established practice now. So that's got quite wide-reaching implications for many different employers in different industries, particularly where you've got staff who are working regular voluntary overtime. And it clarifies that holiday pay should reflect normal remuneration, which can include more than basic pay. So employers really need to review their holiday pay calculations to ensure that you are complying with this ruling. Breach of contract is another very popular type of claim that arises in tribunal matters. And these can occur in various different ways. One is where you have a unilateral change to terms and conditions, normally by the employer. There could be a failure to pay contractual benefits, a breach of restrictive covenants, or constructive dismissal. So a common scenario is that we see is changing an employment contract where there's no consultation or agreement by the employee. So this can then lead to a constructive dismissal claim where an employee ends up resigning because there's been a fundamental breach of contract by the employer, which is no longer tenable for the employee to work. So they resign and claim constructive dismissal. And a key case in this area is Kellogg and Root versus Fitton. And this case really examined the limits of mobility clauses in employment contracts. And these mobility clauses are where you have some wording in a contract which will allow the employer to effectively move location, and the employer has to move with that change of location. And in this case, the employer tried to rely on a mobility clause to require employees to relocate from one location in Greenford to another in Leatherhead. And the Employment Appeal Tribunal said in that case that enforcing the mobility clause in that instance wasn't reasonable, despite the fact that it was in the contract, that it was written in there. So this case is quite important because it shows that even where you have quite clearly worded contractual terms, they might not be enforceable because their application is actually unreasonable in the circumstances. So it underscores the need for employers to apply contractual terms fairly and reasonably. And even where you appear to have wide discretion, really think about, the overall circumstances in that matter to see whether there is an enforceable term. Next, we'll be looking at whistleblowing, and these are protected disclosures under the Public Interest Disclosure Act, which are increasing in prominence. There's a few elements which need to be shown in order to claim a protected disclosure. So firstly, the disclosure has to be in the public interest. The worker must reasonably believe that the information shows specific types of wrongdoing, and the worker must follow the correct disclosure procedure. We've got quite an interesting case in this area, Convi versus Gulf International Bank. That was a Court of Appeal decision, and it provides really crucial guidance in whistleblowing claims. The employee was dismissed after making protected disclosures about certain legal risks in her company's operations. And the court really distinguished between the protected act of whistleblowing and the manner in which it was done. And that's a really important distinction. So while the disclosure itself is protected, she was dismissed because of the manner and approach she had taken in making that disclosure, which then damaged working relationships. So that case helps employers understand that there is quite a fine line between whistleblowing and potentially dismissible conduct regarding the disclosure. And it really emphasizes the need to have a very clear whistleblowing policy and carefully handle disclosures to avoid potential claims. These types of disputes can have significant implications for employers, and so it's really important to understand the nuance of each type, and stay informed about recent case law. And in employment law, there's a lot of case law. And implement robust policies and procedures, which are really crucial for effectively ensuring risk management and dispute resolution. And as you probably all know, disputes can be costly and time consuming. And in the next session, we'll discuss how to address them early on, and potentially save your business from spending significant resources. So looking at how we address employment disputes in early stages, the key thing here is that early intervention can save time and money and actually preserve the working relationships as well. So the first thing is to have an effective internal grievance procedure. It's got to be clear and accessible, and it's, you should think of them as your first line of defense. So with a robust grievance procedure, the kind of thing that would typically involve is encouraging informal resolution where appropriate, then having you have the formal written complaint, and then there would be a prompt and thorough investigation, followed by the grievance meeting, and then you have the written outcome and potentially an appeal process. So our top tip in this area really is document everything. And that's not just because lawyers love documents. It's meticulous record keeping can really assist in defending a claim. It's so important to document every stage as much as possible, because that will really assist in dealing with the matter. Mediation can also be quite a powerful tool. And it's particularly useful for interpersonal conflicts or where you want to preserve the employment relationship. So if you have a scenario where you have two senior managers in conflict, and that's going to start affecting team morale, instead of starting formal proceedings, you could try to bring in a mediator. And the result might actually be you find a mutually agreeable solution that addresses all those underlying issues between them and actually improves the working relationship. And that's going to assist not only with those two particular individuals, but the wider team as well. And the benefits of mediation is that it's confidential, it's voluntary, and it's quicker and cheaper than formal proceedings. We'll also look at early conciliation through ACAS. So before an employee can bring a tribunal claim, they must notify ACAS and go through early conciliation. That is a free service, and it's mandatory before a claim is issued. So here's how it works. The employee notifies ACAS. ACAS then contacts both parties, and if they both agree, a conciliator will try to work between them to facilitate an agreement. It only works if both parties agree. So if one of them doesn't want to go through it, that's the end of the early conciliation process, and the employee can then issue a claim. The whole process can last up to 6 weeks. Settlement agreements is another way of potentially resolving a matter early on. And sometimes it's the best course of action is to part ways. And, a settlement agreement is really going to provide a clean break for both parties. There are some key components for a settlement agreement in employment matters. So these are specific things that are required in an employment settlement agreement. And those are things like it must be in writing, the employee has to receive independent legal advice, and it should also specify the complaints that are being settled. There's also the benefits of potential tax, of trying to resolve the settlement can be very beneficial to an employee, because often the first £30,000 of a genuine compensation payment can be tax-free. But it's still not always as simple as that. It's quite crucial to structure the settlement correctly to avoid any unexpected tax liability. And it's very crucial to understand that that payment cannot be made in relation to a notice period. So a notice period payment is always going to be taxable. So by addressing disputes early through these methods, you can often avoid the need for formal proceedings. However, if a tribunal claim does arise, you'll be well prepared to defend your position, which brings us to our next topic. So despite your best efforts, sometimes formal proceedings are unavoidable, and we can have a look at how to navigate these effectively. So in terms of preparing for an employment tribunal claim, when you receive the claim form, which is also called an ET1 form, the clock starts ticking immediately, and you have 28 days to respond with your response, which is known as the ET3. And that's really a hard deadline, very hard to get an extension in those circumstances. And as soon as you receive the ET1, you want to start taking some preparation steps, which are going to include gathering all the relevant documents and communication. Think about and brief and identify your potential witnesses. And it's also really helpful to have a very clear chronology of events so that you can think about the timeline of what's happened and what your position is, and set it out very clearly in your defense. Key strategies for defending claims. The first one is to assess the strength of the claim objectively. So, we often see employers very emotionally invested in proving that they were right, rather than strategically defending the claim. And it can become a point of principle. So you might have a scenario where an employee claims that they were dismissed for whistleblowing, and your investigation shows that they were dismissed for poor performance, but the timing looks a bit suspicious. So here a strategic approach is going to involve demonstrating the robust performance management process, while at the same time also showing how you support and protect whistleblowers in your organisation. Remember, the tribunals place significant weight on procedural fairness. So even if you had a fair reason for dismissal, if you don't follow a fair procedure, you can still result in a finding of unfair dismissal. Now we can look at the hearing process. So obviously tribunal hearings can be quite daunting. What you can expect from the whole process is slightly less formal than a court hearing. But the process itself is very similar. So the claimant will present their case first, followed by the respondent, the employer. Then witnesses will give their evidence, and then they will be cross-examined. The tribunal might ask questions throughout that, and then both sides are going to have the opportunity to make their closing submissions. One of the most common pitfalls we can see is over-preparing witnesses. So, obviously you need to prepare, that's crucial, but witnesses do also need to be encouraged to give really honest, spontaneous responses rather than giving quite a rehearsed answer. A tribunal is going to be able to pick that up. But also, it's really important just to answer the question that you're being asked, rather than going on into a lot of detail, because that's where you may trip up. So it's important to keep your answer very specific to the question that is being asked. Appeals to the Employment Appeal Tribunal can only generally be made on points of law, not just because you might disagree with the outcome. And the time limit for making an appeal is very strict again. So it's usually 42 days from the date that the written reasons for the tribunal's decision were sent to the parties. In our experience, successful appeals often revolve around procedural errors, or where the tribunal has misapplied the law. So, for example, you might have a tribunal that's failed to properly consider the range of reasonable responses test that is available in an unfair dismissal case. Now we're going to look at the understanding how the financial implications of employment disputes is really going to be crucial in making an informed decision. So when you look at potential damages, they can be quite significant. So for unfair dismissal, the maximum compensatory award is the lower of 52 weeks' pay or £118,000 and £118,223 from 6th of April this year. There's also a basic award that's based on your age, length of service, and weekly pay, and that's capped at 21,570. Discrimination claims, on the other hand, they have no upper limit. So, we've seen awards can sometimes exceed £1 million in very extreme cases. They typically include an injury to feelings award, and that can range quite massively depending on the severity of the discrimination. So they start at just over £1,000, £1,200 to about £60,000. The cost considerations in employment tribunal also needs to be considered because unlike in civil litigation, costs don't typically follow the event in tribunals, which means that each party is usually going to bear their own costs. You can sometimes see a cost order being made for unreasonable behaviour, but they are rare. And defending a claim to a full hearing can cost you anywhere from £10,000 to £50,000 or even much more, depending on the complexity, on the number of claims and witnesses and so on. So when you think about the potential cost of litigation and you've got to balance that against potential settlement. And when you're deciding whether to settle a matter or to litigate, you should consider various things. So the first most important thing is obviously the strength of your case. And the potential damages and legal costs are obviously significant too. You also might think about the management time and the business disruption that might be caused by the case, and also potentially reputational risk if it does become a case that's interesting to the media. Sometimes they publish these cases. So, for example, you might have an employer who faces an unfair dismissal claim, and the potential maximum award might be, in that case, £45,000. And you might have very strong prospects of success, but legal costs are going to be estimated at 25,000, let's say. You end up having a settlement discussion, which results in an agreement at 15,000. And then you can really see that not only have you saved quite a bit in terms of the amount that's being paid, but you've also saved significant management time and legal costs as well. Shouldn't overlook insurance. So employment practices liability insurance can cover the costs of defending claims and any awards that are made. Also, there's legal expenses insurance, which might also assist with tribunal claims. Insurers often require notification at early stages and may influence the strategy that is taken in a matter. So you've got to have a look at the policy terms and think about, whether to pursue that. So in conclusion, while employment disputes can be challenging, if you think about early intervention and how to really think strategically and have a clear understanding of the financial implications, that's going to help you navigate the matter successfully. Every situation is unique, so it is always worth seeking specific advice for your circumstances. So that concludes the main part of our webinar. We also have a publication which you might find useful, which is a guide to UK employment disputes. You might also be interested for our upcoming event, which is Managing Employment and Employee Performance, the Legal Considerations and Best Practices, which is going to be on the 17th of June. We're going to answer your questions shortly. So whilst we give you some time to submit them, we'll just take a little minute to talk to you about LegalVision's membership. So by becoming a LegalVision member, your business is going to get unlimited access to our full team of specialist lawyers for all your business as usual legal needs, which means it's really like having your own in-house counsel for a fraction of the cost. And our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, unlimited domestic trademark registration, and much more than that. So as a LegalVision member, you don't have to worry about the cost of lawyers, and we'll take care of all the business as usual legal work, and you can focus on running your business. To learn more about how membership can help you, you can request a free consultation when the survey appears at the end of this webinar. And now we'll just answer some of your questions that have come in. So the first one is about the Charity Commission's influence on employment issues, guidance on employment issues. So whilst the Charity Commission, they don't directly regulate employment matters, they might have some influence, and it's obviously important to have good governance, and a key focus of the Commission, is going to be looking at employment practices. So, the charities are going to have a responsibility to adhere to employment law, just like any organisation does. But you're also trying to meet the Commission's expectations for the way that the charity operates. So I guess they can intervene if an employment issue is going to threaten a charity's reputation. But otherwise, it's just about ensuring that you're very vigilant about your employment practices, and making sure that you maintain the procedures within the Charity Commission as well. The second question we've had is how to address employment issues where there's been staff abuse, and other issues corrupting the system, other issues in the workplace. So you're going to have to think about quite a comprehensive strategy, I think, when we're talking about tackling staff abuse. So the first most important thing is going to be having a robust policy that really defines what acceptable and unacceptable workplace conduct looks like. You want to have a very thorough and impartial investigation procedure. I think having training for managers on how to recognise that behaviour and address the abuse is also really important. But also offering support for any victims, whether that's a counselling service or some kind of mediation, like I mentioned earlier. And then, of course, if the matter is serious enough to warrant it, then you would be taking appropriate disciplinary action against the people who have done that. The key thing is to try and create a culture of accountability and support. So which is really trying to prevent corruption that can arise if there's abuse and that goes unnoticed. So really being proactive to transform your workplace culture is going to protect your organisation from being challenged legally. And Another question we've had is about wanting to know more about constructive dismissal and how to handle it when an employer is not being fair and trying to force you to leave. So the first thing is that constructive dismissal, as I said, that's really a situation where an employee feels really forced to resign because of the employer's conduct, and they've essentially breached the employment contract. So, and it needs to be very prompt. You can't wait around weeks after something has happened and then claim that you are resigning because of that. You need to do it pretty quickly after it's happened. But if you find yourself in this situation, again, keep detailed chronological records of everything that demonstrates the unfair treatment. If the company has a grievance procedure, then really utilize that to formally address your concerns. ACAS have helplines, so you might want to seek some impartial advice from them, but also, going to a qualified employment solicitor to give you advice on how to manage that situation and, negotiate potential way of resolving it without having to go to legal proceedings, if possible. There's obviously timelines as well that you need to bear in mind. So that's really important. So obviously for unfair dismissal claims, it's currently 2 years, but also you've got 3 months after for bringing a claim after leaving employment. Just see if we have any other questions. That's all the questions that we've had today. So I hope that this has been valuable to you. If you do have any other questions or you want to find out more about how we can help you, then if you can submit your details in the survey at the end, then we'd be happy to do that. And if you could also complete the survey, that would be really appreciated. Thanks very much, and thank you for joining us today.